Can I request everyone to take their seats? We'll be starting with the next session very soon. The next session we have is by Secretariat on what experts think of lawyers and vice versa. Can I invite on stage Ms. Rhia Marshall to give the opening remarks?
थोड़ा सा इधर हो जाए. Why don't you I can Rinal, I can stand with you. It's just easier. Not the first one.
Sorry? Yeah, the Western Mine. Yes.
Jason Ambry, Jason unclear. This was me, Charles, and I think maybe yes, they sort of sit over to me. I trained with, so it's a little shame. I mean, decent chat, I guess. So
I am told that we're waiting for 5 minutes, so we'll start in 5 minutes. Yeah. Good morning, everyone. Can I just check if everyone's able to hear me clearly? Some nods. Okay, thank you. My name is Nishant Nath Singh. I am a lawyer in the International Arbitration Department at Stewart's in London, which is the largest disputes-only law firm in the UK. A very warm welcome to all of you, and a big thank you to the Secretariat team, particularly Mrinal and the MCIA team for giving me this opportunity. Our session today is titled What Experts Think of Lawyers and Vice Versa. And we have a great mix of panelists here today, who I will introduce shortly, on both the legal side as well as the expert side. So we can hope that by the end of the session, we will have a well-rounded understanding of what lawyers actually think of experts and vice versa. And I can tell you it's not all good things. Before we delve into the panel session, I want to take this opportunity to introduce the India Promise. Given this is a discussion on arbitrations in India, and this is India ADR week, I thought it was an opportune moment to do so. So the India Promise is a diversity initiative driven by Stewart's and Sharina Pettit, who is the head of international arbitration at Stewart's. And the aim of the initiative is to boost the visibility and recognition of Indian arbitrators. And as someone who has been working on arbitration matters for a number of years, it's become more and more apparent that Indians are not getting the same level of representation on international arbitration tribunals. And so the goal of the India Promise is to make that a thing of the past. How we intend to do that is to actually start by getting the word out there. And for starters, you would have seen on your tables there are some business cards. If you haven't seen, they look like this, and they have QR codes at the back of them. And what I want to say about the initiative is that it's not just an initiative by Indians and for Indians, and it would not work if it was just that. Its success is very much dependent on all arbitration practitioners and users of arbitration to come together to spread the word. So please do look at it, sign up to the India Promise, spread the word amongst your colleagues and clients, and let's try to make sure that arbitration is seen as a diverse and inclusive community. I'm now going to move on to introducing a fantastic panel. And this is not in any order of preference, it's just what my cheat sheet says. First, I'd like to introduce Amit Garg. Amit is the Managing Director and founder of Secretariat's Asia Operations. He's also an adjunct assistant professor at the National University of Singapore. Amit has over 25 years of construction experience and has worked as a delay expert on disputes involving some of the largest projects in the Americas, Middle East, Asia, and Australia, with a particular focus on oil and gas, energy, and transport. As part of these engagements, Amit has testified in arbitrations across various jurisdictions under all major international arbitration rules. He's consistently recommended by industry publications as one of the leading construction delay experts globally. Second person I'd like to introduce is Mr. Sanjeev Gemawat. Mr. Gemawat is the Managing Director and General Counsel for the SR Group. He has over 3 decades of experience as head of legal, risk, and corporate functions of top multinational corporations across various industries. He's recognized as one of India's finest in-house counsels and is accredited by the Law Society of England and Wales for his outstanding contribution to the in-house legal community. Mr. Gemawat is also one of the founding members of the General Counsel Association of India. Next, I'd like to introduce Kelvin Poon, SC. Kelvin is the Deputy Managing Partner of Raja & Tan in Singapore and heads the firm's international arbitration practice. He was appointed Senior Counsel in January last year. Described as a standout arbitration practitioner and a deep thinker with a solution-oriented approach, Kelvin has represented clients in a broad range of high-stakes commercial, construction, and investment disputes. He's consistently ranked in the legal journals for his expertise in commercial litigation and international arbitration. Kelvin is a fellow of the Chartered Institute of Arbitrators and a panel arbitrator of the Singapore International Arbitration Center and the Delhi International Arbitration Center. He's also a member of the ICC Commission for Arbitration and ADR and a track leader of the ICC Task Force for ADR and Arbitration. Next, we have Nitesh Jain. Nitesh is a partner in the dispute resolution practice at Trilegal with a focus on court litigation, international domestic arbitration, and insolvency matters. He has significant experience working on both complex commercial and transactional disputes. He's represented large conglomerates, banking and financial institutions, foreign investors, Indian and multinational corporations on a wide range of domestic as well as cross-border disputes. Nitesh is featured in India Business Law Journal's A-list and has been recognized as one of the top 10 influential dispute resolution lawyers in Mumbai. I'd now like to introduce Jed Savager. Jed is a partner in Pinson Mason's construction disputes team in Dubai. Having been based in the Middle East and North Africa region for over 15 years, Jed advises on high-value and complex construction and engineering disputes in the energy and infrastructure sectors. He has significant experience of leading large arbitrations across the Middle East and North Africa, with a particular expertise in oil and gas and renewable disputes, as well as having advised on a number of the region's most notable infrastructure projects, including some of the region's most significant airport projects. Jed is routinely ranked as a leading construction lawyer in the major legal directories. I won't do this introduction myself, but I'd like to invite Rhia Marshall, who is a partner at Jerome Merchant and Partners, to give a few introductory remarks.
Thank you, Nishant. Good morning, ladies and gentlemen. A big thank you to MCIA and to Secretariat for organizing this event. The topic for today's discussion, what lawyers think of experts and vice versa. Interesting. I think the use of expert testimony is still at a very nascent stage in arbitration in India. I say this because often when we as lawyers propose appointment of experts, independent experts, the client will tell you that is it really required? Why not, have the losses calculated in-house and put that person up as a fact witness before the tribunal. This said, I think we can all agree that the practice of appointing independent experts in arbitration is certainly picking up steam. We are all seeing the benefit of using experts in arbitration, and this practice has proved extremely useful not only to clients and lawyers, but also to arbitrators. So today, my colleagues will be talking about, what is the role of an independent expert, benefits of expert testimony, what are the challenges that arise, at what stage of the dispute should an expert be brought in. From an arbitrator's perspective, is there any value add to having an independent expert prove a set of facts as compared to, say, an employee of a company? And finally, can a party-appointed expert be considered truly independent? So with that, I will hand over to Nishant to start the discussion.
Thanks very much, Rhia. Right, without further ado, I want to move on to our panel session. And I'd like to start by asking the panelists an open question, which is this: at what stage of the arbitration proceedings do you think it is most ideal to appoint or engage an external expert witness? Open to views from anyone.
Hi, Nishant. Morning, everyone. I think, if you can, when you start getting legal notices, right, you can see where this is going, right? In terms of what sort of claim is coming against you, right? It's best to start interviewing experts and get someone on board, right? So that you start getting their thoughts, right? If not at that stage, but surely at a stage where you get notice for arbitration, right? I don't think you should wait where all pleadings are over and then you're thinking, oh, let's get an expert, right? Because then that expert will come up with some expert opinions which may not match with what you have pleaded cases. So I think best is at the notice stage, if not before.
Go on, Amit. Do you have any countering views as an expert?
Definitely not. I think, obviously, it goes without saying. I think earlier the better is the short answer. There have been occasions that we've been reached out by counsel when the rebuttal expert reports are due. And that's the first time they engage an expert because they've seen somebody else engaging an expert. And again, as Rhia mentioned, we've seen that happening in India quite a few times. I sit in Singapore and we'll receive requests quite late in the game. I think, obviously there are certain expert disciplines in which experts can come in later. So it depends on specific expertise. But certain other disciplines, you definitely need experts to come in much, much earlier. In fact, I would say even before a formal dispute has been filed. Because, there are 3 or 4 reasons. Reason one is the experts can actually give guidance to not just the client, but obviously the instructing solicitor as to what are the areas to focus on. And I'll give you a very small example. We were instructed on a matter in China, which was a $6 billion sour gas exploration and processing plant. And this is a plant that's spread across 20 kilometers, numerous extraction plants and processing units. And the project was supposed to be finished in 2 years, took 7 years to finish, was 3 times over budget. When the solicitors were involved, and they were a big team of international solicitors involved, the project team gave them a lot of feedback as to what had happened, but it was very difficult for them to understand where to focus on such a big project. So when you bring on an expert at that stage, the experts can actually help you focus the efforts in the right direction. And I think that's usually quite useful. So earlier the better is the short answer.
I'd agree with all of that, Amit. I mean, I think I'd just come on just to, in my experience at least, a lot of parties, so in my jurisdiction, Middle East, seem to view the notice of arbitration as being the thing that will unlock settlement. And so often the notice of arbitration, request for arbitration is fired in the hope that that will unlock the position. Often, in my experience, it has the reverse effect. But in doing that, they've not really invested the time and effort in understanding their dispute. And so, we were hearing earlier about mediation and when to use mediation. Well, settling disputes, understanding what your true sort of exposure is, you only can really do that when you engage experts. And to come back to Amit's point on construction engineering disputes, certainly getting involved before the notice of arbitration is quite important. It's quite important also because of jurisdictional challenges. So coming to Amit's point on that project in China, if you've got a FIDIC contract where you've got to put your disputes through to an engineer who's got to determine the delay claim, for example, if you've put your case in on a set of delay events that are completely different to what maybe Amit or another expert might come in and say, well, I've done the analysis, I don't think it's those events, it's these, you possibly could have the wrong dispute that's gone to arbitration and a series of jurisdictional challenges that then come on during the arbitral process, which drives up time and cost. So they were just a couple of points from me.
Thank you. I like all the other panelists here, I think it is correct that it is useful to get experts on board early. I would just draw a distinction between a consulting expert and a testifying expert. I think it makes a lot of sense to get an expert as early as possible to guide you on your case. But whether you want to get your expert witness in or not at an early stage, I think that's something that we should all bear in mind carefully. There have been some decisions in various arbitration awards where tribunals have noted that if an expert has been involved in the case for a long time, that could open the expert to some questioning at cross as to whether there is unconscious bias or not in taking certain positions they have on the opinions shared. So that's the first point. The second point is, I think it's Amit's point. Whether you get an expert early or not also depends on the discipline involved. I mean, in the context of construction, I think that usually is a sort of area which makes a lot of sense to get an expert in early. If you're looking at damages, if you're a claimant, naturally you want to explain early as well, so you have some sense to what the amount is going to be when you succeed in the claim. But in other disciplines, it might make sense for the case to develop a bit more, because ultimately whether the expert evidence is going to be useful or helpful to the tribunal depends on how the issues are framed. So it's a bit of a balancing exercise. So generally I agree as early as possible, but be cautious.
Thanks for having me here. I would say that handling litigation is not a simple thing. Litigation is a strategy. So as a GC, the way in which I look at it is that our role is to build a collaborative team, and collaborative team of internal as well as external experts, which include these experts. That's not the formal one, but then a start should happen at that point of time. And thereafter, you take it forward accordingly. So as far as the specific question is concerned, at what stage, I would say certainly informally before filing of the claim, but then you will have to formalize it somewhere. Yeah. Thank you.
Thank you. I think there's definitely a theme arising over there that early engagement of experts is seen as quite beneficial. I'd like to turn to our resident expert of the panel, Amit, and ask you some questions on your views as an expert and what you think of lawyers. And my first question is, what are your expectations as an expert from instructing counsel and or the client?
I think the first expectation is something that we just touched upon earlier, which is get us in earlier. It allows experts to really dive into the detail rather than pressurized on the time. So that goes without saying. I think provision of information on big complex projects is always a daunting task. And the manner that information is provided allows experts to do their job better if it's done nicely. And so I think there are probably 2 or 3 aspects that we suggest counsel and clients to pay particular attention to. One is obviously don't think of us as a repository of documents where you can just dump everything that happened on a project and then we are supposed to go through it. We can, but it takes a lot of effort. So progressive explanation with documents that is being provided is very useful. I think it also, I think one of the things that is, I'm talking from a construction delay expert's point of view, is we walk in on projects sometimes 2 or 3 years after the project is over and the matter is in dispute. Frequently, the fact witnesses on that project have moved on to other projects, and it's difficult to get their input. But as experts, we need to understand what happened on a particular project. So it's important for clients and counsel to make sure the team that actually worked on that project is available to provide just factual guidance that might otherwise not be available. I think there is kind of a touchy subject, which is obviously the expectation in terms of what clients and counsel think about fees. I think there's no doubt.
Is what I would say always.
Yes, that's the general refrain, and particularly for delay experts, even more so, that we are the most expensive experts. But look, I think a good amount of work does take some amount of effort by good people. And I don't want to belabor this point, but if you pay peanuts, you'll get monkeys. And if you try and find the right expert, and then you need to engage with that expert in terms of, just don't select experts purely on the basis of the lowest bidder, is the short suggestion that I would make. There are maybe a couple of other suggestions for instructing solicitors, and again, no particular order. One is, we obviously see sometimes clients who are first-time litigants or first-time into an arbitration, and their understanding of what an expert does and their expectations from an expert might be a little bit different. And I think it's always useful from, if a counsel or instructing solicitor guides the client saying that, look, this is what the expert, this is the boundaries of what an expert can say in terms of the technical discipline. So for example, a delay expert may not venture into what you would call items that are beyond the remit, such as causation related to design issues, etc. So it's extremely useful if you have a solicitor who's working together with the client and explaining the client that this is what this expert can do. And because there are certain aspects of the dispute that might not be hand-labeled by that particular expert, then you try and find others. So that comes into realizing the value of individual technical discipline experts. So the tendency, and again, as in different jurisdictions, as there's a more and more maturity in relation to arbitration, we find that in mature jurisdictions, you will have a multitude of experts, each one dealing with a different aspect of the works. Whereas on occasion, you would run into a jurisdiction, and it has happened in India, where the client would say, look, obviously cost is a concern. I would also like you to handle delay, quantum, geotechnical, and why not some damages as well. And so I think that's probably an extreme, but it's very useful, again, to get different technical experts on board. It doesn't necessarily increase the cost. It actually gets the client immense benefit in terms of the tribunal knowing and trusting what the technical experts are saying. And then lastly, I think, again, this is, we find it tremendously useful if during cross-examination, for example, in the hearings that I've been involved in, It's obviously gratifying, but it's also very useful that sometimes counsel would seek our assistance in identifying the key questions that certain experts should be asked. Sometimes certain fact witnesses should be asked. And obviously, based on the responses particularly provided by the experts, what would be the counter questions? Because sometimes, particularly professional experts are adept at testifying. They know how to maneuver around a counsel's questions. They know what to say to kind of confuse the tribunal. So it's always very useful to have kind of, if the expert says this, then what's the next question? So again, hopefully more and more assistance is asked of us in that respect, and I think that goes some way. Thank you.
Thank you. That's very helpful. I want to touch on the duty of an expert to give impartial and independent evidence towards the tribunal, which is, of course, of paramount importance. And just sticking with the theme of managing expectations, how would you say you find it balancing and managing expectations of instruction counsel or the client against your duty to give impartial and independent evidence to the tribunal?
I think that's a tough question, but on the face of it, this sounds like giving independent evidence versus trying to balance the expectation. These are mutually exclusive propositions. I think in practice, and certainly in good practice, they're not. I think as an expert, my duty always remains towards the tribunal, irrespective of the party that is footing the bill. I think this is not a binary question in the sense that it's not, is the expert my expert versus is the expert an independent expert? I think it's a question of, when it becomes a binary question, that's where it's an issue. So on occasion, we've had clients, and sometimes, very rarely, counsel thinking of the expert as their hired gun. And I do think that's a short game, because one is bound to lose. And the reason is very simple. And I've been in front of tribunals internationally. It is very easy to lose a tribunal's confidence in one's testimony if the expert starts to be a bit too biased. And think of whatever the expert is proposing, say, there would be elements of the findings that are pretty clear and are likely to fall on the expert's side. There would be some findings which are in the middle ground, right? And then there's some findings which are a stretch. And if an expert tries to win them all and tries to push the third category, frequently we see it's the other way around. The tribunal realizes that this expert is pushing the limit, and not only would you not get the extreme position, the middle position where it's either there or either this way or that way, you would certainly lose that, and you might actually lose some that might have anyways fallen into your pocket. So it's a zero-sum game in that way, and I think that the whole modus operandi of arbitration is when experts start to become part of the team and collaborating progressively more and more, as Kevin was saying, starting earlier on, there is this tendency to be a bit too exuberant about it, and I think one should be careful about it. I think the best way to do this is to manage expectations of the clients and counsel. Even when there's no doubt there are certain expectations, but how do you manage it? And it goes back to that point that I mentioned earlier, which is if you bring in experts at an earlier stage, as Jed mentioned, even sometimes prior to the notice of arbitration, good expert can carry out an analysis, an objective analysis, an independent analysis instructed by the counsel, which gives the client and the solicitors a true idea of the potential exposure and the entitlement. And when that happens, that can result in significant benefits. And I'll give one example. I was involved in a matter in Australia. This was a iron ore processing plant in Western Australia. a substantive project, $10 billion, and we were engaged on the matter by the contractor for the dispute upwards. The claim values were around $700 million. The matter was construction of the iron ore processing plant, and the project was just 3 months late. And the contractor, a very sophisticated contractor working across the globe, felt that 3 months is a very small delay that it can recover in terms of an extension of time. And as we did that analysis, we were able to explain to them the issues in their position. And once the pleadings were filed, halfway through the process of pleadings, the client and the counsel recognized that the case was not as good as they thought, and they eventually reached out to the other side for settlement. So extremely useful. I think if you do your job as an expert properly, I think it will go much further than just being a hired gun who's just tooting one side's position. So, thank you.
I think I'll say that a good expert is always independent and impartial. So, I want to talk to you, Amit, about hot tubbing and joint expert reports, but I'm going to come back to that question. But I'd like to turn to you, Mr. Gemawat, and as a prominent in-house counsel, and given your experience of having to balance the needs of internal stakeholders as well as external stakeholders, cost is obviously a big factor in your decision-making of instructing experts. So thinking about the cost-benefit analysis, do you agree that independent experts bring significant value add as compared to your own in-house sort of finance teams or people who can advise on delay matters?
Well, I would say not significant advantage. I would say it's needed, it's essential. On all complex disputes, you can't afford to have your litigation strategy without an expert. You would be faltering, and in fact, you would be losing your case. So you need to have an expert. So it depends largely in which industry you are working, which kind of disputes that is, and if suppose by all parameters you need an expert to be involved in a litigation, and which is assuming that that's a complex dispute, then I think it's needed. Now coming to your specific question on cost part of it, I think you need to, as clients or as general counsels, we do rationalize as well, because at times, and particularly when cross-border disputes are there, you need to have some expert testimony, some expert analysis, which would establish the impartiality, independence of the whole project. And I think from that standpoint, cost doesn't matter, because if you can pay to your senior counsel a significant amount, I think expert is making or it's a make or mark kind of position. So you need to have an expert in those kinds of transactions. Now, one comment which I would like to maintain, which you asked to Amit as well, that the expectations of the clients, and I think that is one of the most important and critical factor in the whole issue, because the way in which I see disputes are largely arising out of three situations. One is because of the commercial, changes in terms of, quality or pricing or time delivery or delay in services, and, something of that nature. Another dispute criteria is basically contractual in nature, where you are interpreting the contract in a certain fashion and somebody else is interpreting differently. It's a second part of it. But then there's a third part of disputes, and which is largely significantly dominating the minds of lawyers and minds of clients as well, which is behavioral in nature. And that behavioral is that I would teach you a lesson. Now, this particular thought of teaching you a lesson would result into number of thoughts in the minds of people, and then the dispute happens. Now, in that construct, the expert needs to balance it out, because I have seen those kinds of reports of experts as well. When they are filing some reports, it's all nonsensical with those kind of figures. Whether they can invite that kind of confidence and conviction of the tribunal, in fact, that is a losing proposition at all, even at the first instance. So I think that needs to be kept in mind. I hope I answered your question.
No, you did. That's very interesting. Thank you. And you touched on costs. If I can ask this, what are some of the other key factors that you would consider or evaluate an expert on when you are considering appointing that expert?
Well, the very purpose of appointing an expert are largely two reasons. One is there is somebody who is having the global knowledge, who is knowing the industry, who is knowing the nuances of the industry. So this is one large part. The second part is that he is a trained expert, trained in the sense that he can present before the arbitral tribunal, he can give testimony on my case, and also he has that credibility, credentials, whereby the tribunal is also believing that this is an he can't do, he can't falter, or he will not be giving me a nonsensical kind of report. It's basically a credibility issue. I think these factors do matter. So if you ask me which kind of expert, of course, these are the basic credentials. But then besides these basic credentials, the expert should be meeting our expectations as well. And our expectations are, he cannot be, because ultimately it's all said and done. All litigations are views and counter views. There are certain views where we have always strong views. Now he needs to understand our views, our concerns, because ultimately we are business organizations, and that is very, very important, because unless he understands our concerns, he can't be doing justice to our work. So I think that is the major differentiator as far as engagement of expert here.
And just on that theme of instructing experts, would you tend to, or would you say you have a preference of approaching experts directly, or would you sort of defer more to your instructing counsel? The reason I ask this is because what we see a lot of times is that when our clients are quite comfortable with deferring to us when instructing specialist legal advisors or barristers or senior counsel, when it comes to experts, we're seeing that now the client is quite invested in having that choice and actually being the voice of that decision making. So just some thoughts on that would be quite interesting.
Well, it's both ways. And as I said in my opening comments, that ultimately our role is to form a collaborative team. And collaborative team essentially means that all our internal and external experts should be together with the same meeting of minds. And I think even if at times we directly engage or we just bounce off our idea with the expert before we engage with the external lawyers, ultimately there would be at certain point stage where the external lawyers as well as experts, they should have that alignment also. So that is very, very important, because at times it's very difficult if the external lawyers or law firms or the lawyers, they are not aligned with the experts' thoughts and all that. So it becomes very difficult. So normally I would say that it's a collaborative effort. We also bounce off our ideas that we are going with this particular person. At times experts are not even knowing that we are in fact contacting them through our law firms, etc., because we want to make that also, distance needs to be maintained to that extent. So we do all that stuff, but then we largely know, and most of the organizations, I think, wherever the GC's function is a strong function, they know that, whom to engage and whom not to engage here. Thank you.
Thank you. I want to move on to discussing with you, Kelvin, and with your sort of barristerial hat on. What would you say are the sort of different styles of cross-examination that senior counsel or barristers would employ when cross-examining expert witnesses? And would you say you have a sort of preferred style yourself?
No, I don't have a preferred style to cross Amit or any individual expert. I think it's fair to say that when you are talking about cross-examination, it is not a conversation between you and the expert. It's a conversation between you and the tribunal through the questions you put to the expert. So I don't think there is a different style. But what invariably happens when I'm cross-examining an expert is that I tend to find myself working much harder to get the questions out. Because you just have to get it to a point where it's, first of all, you are dealing with someone who knows the subject much better than you. You need to simplify it to a point the tribunal understands and make it interesting enough for the tribunal to realize why it's important to listen to the question. So it's quite a, there are many facets to the job. And so I'm back to the point which I think Amit mentioned earlier. I think it's important, therefore, to have an expert on your side that you can work with to work through, I think, some of the ways of presenting the point clearly. I always come back to the example that I encountered now maybe 12 years ago. We were trying to explain to the tribunal whether the bridge that was being constructed above the tunneling works, the subject matter of the arbitration, was stable or not. And there are a number of different concepts that we had to share with the tribunal. One was tension, and there was stress at the foot of the pile. So it sounds simple enough to most of us in this room, but for some reason the tribunal couldn't quite get it. So my expert then came along, and all he did was to show a picture of a woman's high heel shoes. And he said, look, it is a load bearing. That's where the heel is touching the ground. That's load bearing. And if it's tension, it's where the strap is at the heel, tugging away at the heel, and that's tension. And through that very simple photograph, I think it was easier for us to explain and then lead on to a series of questions to attack the other side. But so, back to your question, is there a specific style? No. It's probably more a style that's catered to the particular tribunal in question, but always assisted by having able experts next to you who are able to present a view that's fair, impartial, and accurate.
Thank you. You mentioned it's harder when cross-examining expert witnesses. Are you saying harder in the context of doing it against a fact witness? And is there a kind of different approach that you would take with an expert witness versus a fact witness?
Yeah, so when I say it's harder, it's not because of the characters involved. I'm not saying because when I cross-examine someone for Secretariat, they are very tenacious and they are not given. I think we've all seen fact witnesses, they are equally tenacious, and they don't give in. The difference is the subject matter. Yeah. When it comes to facts, they are facts. All of us live lives through facts, and we can tell when a fact is believable and not believable. But when we're dealing with a technical question, that becomes a bit more tricky. And so a bit more effort I don't want to say a lot more effort is probably needed to craft a sequence of questions that can make the point clear and persuasive.
Thank you. I want to ask you, do you think there's a difference in how an arbitrator views an expert report versus, in the context of litigation proceedings and court proceedings, how that would be perceived by a judge? And that could be in the context of a civil suit or, a challenge to an arbitration award. It's just that kind of different perspectives.
The question of the court and arbitrator dichotomy, first of all, we need to draw some lines as to what sort of court are you talking about. And in terms of my experience, it's largely in a Singapore court. And if you're looking at a Singapore court, I think the approach between the tribunal and the court are largely similar. The judges and the arbitrators do want to try their best to get to the nub of what the technical question is and to see if they can reach a fair resolution to the problem. But between an arbitrator and the court, there are some advantages still, I think, in the arbitral process. Not arbitrator, but the arbitral process. Particularly if the arbitrator or the tribunal gets involved in the formulation of the issues at the early stage. I think that really helps, not just me as counsel, but the parties understand what needs to be done to focus the questions. One of the most challenging problems that you face as counsel is when you are asking questions, you're looking at the judge, and you're not sure why there is no reaction. Is it because the judge doesn't think that the question is important to the case? Is it because the judge doesn't understand my question? What is it, right? And I suppose the regular interactions that you may have with an arbitral tribunal in the lead up to a hearing can help address, I think, some of those concerns. And that makes the arbitral process in that way more comfortable when dealing with expert questions. But ultimately, if you're talking about whether you want to ensure that the tribunal or the court takes active interest in the expert discipline or the question, it comes down to how you formulate the issue and how you can make it clear to the judge or arbitrator why this point needs to be decided. I was just having a chat with a partner yesterday before I left, and there was an issue that was being put to trial that's going on in court today, actually, in Singapore, where I couldn't understand why it was even an issue. And it's no surprise that the judge is also asking that same question of the parties. And is it any surprise then when you get to the cross-examination, the judge takes no interest? So I think it's really a combination of many factors, and as Sanjeev mentioned, it's really a collaborative effort on the entire legal team to make sure whatever is being put forward is relevant and the points that are made land and make an impact.
Thank you. Any further views from the panelists on that point, in any different court perspective or?
I just was going to come in on the point about early engagement, and it's something Amit touched upon, but Kelvin really brought out, which is, we're all familiar with expert joint statements and using that as the method to narrow the issues or bring the issues out ahead of the hearing. In fact, what I see very little of is early expert engagement right at the beginning of the process. So first CMC, having the experts along from each side, to talk about how they're going to engage. Are we going to agree a joint data set? Are we going to agree methodology? A lot of these things are actually left quite a long way back. So, almost the die is cast because you've got expert report, opposing views, etc. A lot can be done by engaging with the tribunal, and that comes down to really counsel's role, I think, in encouraging that process through its engagement with the tribunal and then helping the experts along that journey. So, yeah.
Thank you. And that's sorry, Nitesh, go on.
So from the Indian court perspective, right, we don't see lawyers instructing experts, right? I mean, we file cases claiming damages of millions and billions, right? But when you see the underlying report, there is none, right? There'll be some sort of the internal CFO, the chartered accountant. He would, basis the balance sheet, would do some calculation, and that will be part of the witness statement, right? But I think, I mean, we should take this seriously, right, when it comes to the Indian court system, and for that matter, domestic arbitrations, right? And I'm very glad that sort of MCIA has selected this particular topic, and thanks to Secretariat for sort of setting up a panel on this, because I mean, we keep talking about arbitrations, various issues in relation to arbitration, but I think experts is a very critical part when you deal with an arbitration, not limited only to international arbitration, right? Just because it's seated outside India, that you get serious and you get some big experts, right? But I mean, it applies very well whether it's domestic arbitration. I mean, you can have, various institutions sitting in India, right? I mean, there may be international parties, so you will have an expert, right? So therefore, you should have serious thought when it comes to domestic, and also the court, right? Because the assistance, you have to give it to court, and it becomes fairly easy, right, when you are in court.
Yeah. No, you're completely right. I think there is some serious transferable benefits of the use of experts in international arbitration that is now, being actively considered by the Indian courts and domestic arbitrations. We were touching on expert reports, and I want to come back to you, Amit. Over the years, we've seen growing use of joint expert meetings, joint expert reports, and so also, hot tubbing, which is now quite actively being, considered by tribunals and being ordered by tribunals. In your view, what would you identify as the sort of constructive approaches to joint expert meetings, joint expert reports, and hot tubbing?
I think Jed mentioned something very important, which was talking about early engagement of experts. And certainly I can speak from a delay expert's point of view, is that there's a commonly used phrase of how two ships passing by in the night, like two delay experts on a complex matter can be exactly like that. They would have proceeded without a joint statement in their own methods of analysis and sources of data and reached a conclusion which, when the tribunal compares to the other expert, it's very difficult for the tribunal to understand and distinguish where are the real points of agreement and disagreement. So early engagement is key. I think in terms of certain best practices, and this is more speaking in terms of engaging with other experts, I think I like to personally explore what I call explore the agreeability. Now, this sounds a bit scandalous. It doesn't mean that I'm trying to figure out how much the other expert is going to agree on. It's actually the other way around. I find good experts, sophisticated experts, are more interested in figuring out areas of agreement. And it's actually the less sophisticated expert who will put up a wall and just not agree to anything at all. So, agreeability early on in the process is very useful. Sometimes we find people, again, sometimes driven by the tribunal, but saying that if you can agree certain issues in the joint expert report, that'll be great. But again, it depends on the discipline. But taking delay experts, I would say delay experts coming together on a project of certain magnitude, which has taken over a good period of time to finish, is like having two storylines of the project being completely aligned. It's a very difficult task to achieve. So what I suggest is agree on foundational principles. What does that mean? Method of analysis, a common data set to work with, which is like sources of progress data, for example, or baseline programs. And then as you go forward, you can kind of start to whittle down to the key areas of agreement and disagreement, such that every joint expert report, I think, moves the process a bit further along. Other things that I've seen which have kind of been very helpful as I've seen sometimes the expert process, the joint expert process, go off the rails. The experts don't agree with each other at all. The joint statements are small and are of no particular value. And I've seen an approach being taken, particularly in Australia, where this was a high court, this was a litigation headed to the Supreme Court of Western Australia. It was a matter related to a healthcare facility, and the dispute was between the state of Western Australia and a contractor. And we were appointed by the state of Western Australia on that matter. And difficult project, a lot of issues in dispute. And interestingly, to oversee the joint expert process, the sitting judge appointed a retired judge to be sitting as part of the expert meetings. So we essentially had a kind of a mediator sitting as part of our expert meetings, talking to the two experts so that we didn't go ballistic at each other. And that was, I thought, a very interesting approach. And I wonder if that's something that would be copied elsewhere. But that's sort of a few thoughts.
Thank you. I want to now move on to getting views on the second part of what this topic is, which is what the lawyers' views on the experts are. And I'm turning to Jed and Nitesh in this final segment. And you've obviously represented various clients, in both from sort of the claimant perspective and the respondent perspective. So just to make things a little bit interesting, the question that I ask, if Nitesh, you can consider them with your claimant representative hat on, and Jed, if you can think of it from a respondent perspective. My first question is, what are the key attributes that you would evaluate when you're interviewing potential candidates? So, Nitesh, what would you say are your expectations from the claimant's expert?
So I think the most critical is the honest assessment of the case, right? Because you are interviewing a potential independent expert, right? You would want your expert to get into details of the facts, use their experience. Tell us what are the strengths, what are the weaknesses. And I'll be more interested in the weaknesses, right? Which is where sort of, because those weaknesses, if they don't point out, there'll be limited facts, numbers, maybe, the actual claim will not be there, right? So, basis their experience, their past experiences, right? If they have handled the similar situations, based on that, how's that they can present, right? So it's like lawyers pitching to their clients, right? I would expect the same the pitch from the experts to us, right? What also becomes important, of course, I mean, at some stage, cost is equally important, right? In terms of, and it's not because they are very costly or they are not, right? In terms of the clarity, right? So so client is happy to pay, right? But whether it's clear in terms of what the total damage would be to the client, is it sort of the number is there, not there? What are the various permutation combinations? So clarity from that perspective becomes very, very important. Also, I've seen, so let's say, I mean, there is a big organization, right? And you have a particular person, right? But your dispute involves that you need a particular expert, right? So it's important in that pitch, right, that they get the right expert. It's not about the key person that who's coming and sort of pitching. It may not be his or her domain, right? But to get the right expert who sort of suits my requirement, the case requirement becomes very, very critical. So overall, I think the honest assessment is what at least I look for.
Jed, would you say that there's a difference in how you are approaching it as the respondent party, because you obviously have a more well-advanced case to consider?
No, thanks, Nishant. It's hard to say I disagree with the honest appraisal point. So I think we're aligned, even if I was for respondent or claimant on that point. I think you're absolutely right. Timing, when you're acting for the respondent, often you'll often know the expert that you're up against. That's really important when you're looking at your expert, because ultimately you're looking at parity a little bit. So what you don't want is David Goliath. You want, bearing in mind, back to Kelvin's point earlier, your audience is the tribunal. What you're trying to do is get your case across in the most persuasive way possible. Therefore, how is your expert going to measure up against the other expert? We talked about hot tubbing briefly earlier. If that was to eventuate, how would your expert handle that? That then brings on to some fairly mundane but important points: experience testifying and report writing. When you've got very experienced experts like Amit, that's not an issue. Often it comes up where you've got a very niche technical issue. Let's say it's a turbine failure, something very niche, patented technology, something like that, where you actually have to go to the industry to get expert input. But the expert you get may be a leading expert in the field, but they've not written a report or been in an arbitration scenario. And then the really important thing comes back to how counsel manages that situation is, often engineers, technical experts in that context are solutions driven. Their whole professional life has been coming up with an outcome, but working out whether something was negligent or not, or was good enough for the purpose, is an entirely different question. So those are the sorts of challenges I think that come up, particularly, both for respondent and claimant, but when you're looking at your expert as respondent, knowing who you're against. Also, you will often have the tribunal form, so you'll know your audience. So those are two important distinguishing factors when you're looking at appointing from a respondent's point of view. One last point, because I think it's come up across the discussion, has been team fit. So that I couldn't stress highly enough. Your client, legal team and expert team have got to gel. It's a defence team that you're building, and the client and their fact witnesses need to feel confident that your witness, your expert, is open to their position. That doesn't mean they have to adopt it, but that there is a risk sometimes with independent experts that they come on board, form a very independent view, but it's kind of disassociated with what actually happened on the project. And so there is a little, and often this is where one has to be quite careful about managing those expectations. It's having an expert that's open to those positions, that's open to what the fact witnesses might say, that put a gloss on what the documents say.
Nitesh, do you want to add?
Can I just respond to one point? So while I agree with Jed on the experience, right? So recently I did an arbitration where we were sort of interviewing a lot of experts, and one of the experts came and he was very, very good in terms of his technical knowledge, right? But we asked him if you have sort of testified in the past. He said, no, this will be the first one if you give me an opportunity, right? And I was in fix whether should we give this opportunity or not, but that person was absolutely convincing in his work, right? And we decided to take him. He was opposing an expert, and I think she has more than 30 years of experience, okay? And the counsel that was cross-examining my expert, he has more than 30, 35 years of experience. So my expert called me to say, I mean, I'm against him, right? I said, see, this is what you signed up for, right? So just be confident, just stay with your work, what you've done. And he performed so well, right? And I was very glad on the decision that I took, right? So I agree with, while the experience certainly matters, right? But I think you also have to give opportunity. So it all depends upon, the ultimate work, right? And which is where I think the joint expert sort of plays very well. That's where a junior, senior, right? The two people sort of work together. You get more sort of inputs on the work, and that's how sort of they get trained.
Amit, do you want to add anything to that?
Maybe just a couple of quick comments. One on what Nitesh just said, which is actually I've seen as well. I think sometimes experts who've done this for a very long period of time can come across as, just maneuvering around the questions. And certain tribunals appreciate the candor and, just the, freshness that technical expert brings who's not done this as a professional. So I think there is value to that. Having said that, I'll go back to also what, Kelvin and Jed said earlier, which is a good expert is somebody who can explain complex concepts simply. And I think that's a tremendous, and that should be the criteria of one of the criteria of selecting experts. And I remember that this is a case from a long time back. This was a power plant in Quetta, Pakistan, and we were engaged by an American power plant designer and constructor against the power company. And opposite us was an expert who was a professor from the Princeton University, clearly a very, very accomplished individual. And he had prepared this amazing database that, surprise to us, had accumulated all the progress information and compared it to what was supposed to be carried out in terms of plan. And it was a massive endeavor. As part of his direct presentation, which was meant to last 30 minutes, he was going to explain the analysis that he had carried out. He had 300 slides. And roughly around slide 47 or so, I vaguely recollect, the tribunal said, and he was already 25 minutes into the 30-minute allotted period, and the tribunal said, well, Mr. So-and-so, how much time do you need? And he was at loss. And so, obviously, he had his testimony, the direct had to be cut short, and he was left. That's a very crude example, but the point is, it's not just the background and the technical qualifications. It is the ability to simplify concepts. And I think one last quick point, and I know I'm hammering this point again and again, but particularly when we are facing disputes and appointments in the Indian jurisdiction sector, fees is a touchy subject. I think, as I said before, that's not the only criterion, but also one has to recognize that what you pay to the expert is a minuscule proportion of the overall damages that your client is seeking against the other party or trying to defend. And in fact, you are going to appoint one expert versus the other expert. So the only money that you're paying extra is the delta between one expert versus the other expert. So how small is that delta compared to the overall grand scheme of the money that you're earning? So that's sort of my closing point on that. Thank you.
Thanks, Amit. I want to ask one more question, and then I'm going to hand over to Rhia to bring this all together and give some closing remarks. But it's a slightly controversial, but it's a pertinent question, is how independent or unbiased do you think that an expert actually is? And this is to you, Nitesh and Jed. And that's a more general question, not sort of limited to being claimant or respondent.
So I think good experts are independent, right? And it's in our interest of our clients, and interest of the arbitration that they are independent and unbiased, right? I mean, the tribunal is very, very smart, right? They are able to sort of read, understand where this is going, what is that the expert is doing, right? And ultimately, you win on merits, right? It depends upon what your witness is testifying, right? Because the other side will cross them, right? So my experience has been that they are independent. And there was a survey last year, 2023, where sort of 50% of the respondents said that 55% they said, that they gave favorable report to what the counsel say. And there was around 40% said that they were actually bullied by lawyers, okay, by their instructing counsel to sort of change it, right? But my experience has been, they largely remain independent, yeah.
I'm happy to say I agree entirely with that. And I think, the situations I have seen that have come up where issues of independence have been a problem or credibility has been an issue is one, something Kelvin touched on at the outset, where you've had the expert involved for a very long time, but their role hasn't been carefully managed. So, my experience, there's no problem bringing on an independent expert during the project to provide their preliminary reviews, but setting up that appointment's really important. So they're appointed as an independent expert advisor, and there's no problem then in the arbitration that being disclosed. In my experience, tribunals accept that. It becomes a problem where that role's become a bit blurred, and then the expert's asked, oh, did you help write the claim, etc. That's where it gets more difficult. So again, back to how does the counsel manage that interface, really important point. Other areas had an arbitration now 18 months ago where it turned out the experts on the other side had been engaged on a fixed fee arrangement. Now, it wasn't a success fee arrangement or anything like that, but when that came out, the line of questioning went along the lines of, well, if you'd had a bit more time and money, would you actually have done a bit more work and come to a different view? The concession was, yes, that might have been the case, etc., etc. Again, that's back to credibility. So maybe not so much around independence, but it's all about credibility. As everyone on the panel has said, your audience is the tribunal. You're trying, as Amit touched on, trying to gain their trust. And therefore, giving your expert those tools is absolutely paramount. So, yeah, that's all I'd add to Nitesh. Thanks.
Thank you. I'm going to hand over to Rhia, who's been waiting patiently. But any further thoughts and final thoughts from you, please?
Okay, so we've heard from the lawyers, we've heard from the barristers, we've heard from the ultimate beneficiaries who are the clients, and of course we've heard from the experts themselves. And so what do lawyers and clients really think about experts? We think they're expensive, just joking. I think, with experience, we've learned that it's money well spent. We've used experts now. Like I said, it's a more recent development in India, but having used experts for various matters, we see the benefits, we see how the tribunal responds, and I think we all agree that it's not ideal or important, but it's necessary to have an expert on your team. So now, to sum up, as a lawyer, I'm just going to speak a little bit about, just a minute, don't worry, what a lawyer really thinks of an expert. So I believe that as lawyers, we need to ensure that expert testimony remains objective while still aligning it with the narrative of the client's case. It's a fine balance, but that balance is crucial. The testimony of an expert will only enhance the credibility of a case if lawyers and clients appoint them as genuine truth tellers, whose job it is to assist the tribunal, and not as hired guns, as Amit said, because that only compromises the integrity of the arbitration process and ultimately benefits nobody. So in my practice, I have seen firsthand the impact that a well-prepared expert can have. Expert evidence can shape the tribunal's understanding of critical issues and influence the outcome of the dispute. I've recently worked with Secretariat and with Mrinal on a couple of matters, and it was a fantastic experience and also a very good result. I think the kind of in-depth understanding and the ability to understand the client's business that experts bring is something that we as lawyers can't do, and we definitely need them on our team. So I think that's all from me. Thank you.
Excellent. Well, thank you very much, everyone, for coming here today. I hope you found it interesting and engaging. Big thank you to all our panelists, and could we please get a round of applause for them? And thank you again to the Secretariat and MCIA teams for organizing this, and all our sponsors, which without the money, we can't do anything. Thank you, everyone.
Thank you. Now we'll be taking a short coffee break for 15 minutes. You are more than welcome to bring in your coffees here.